Dear friends, my today's topic is when a person sets on fire on another person, is it extreme cruelty? This was the case before Supreme Court in an appeal, and I'm going into the details. I'm going to the facts of the case. In a man's appeal before the Honorable Supreme Court, challenging his conviction and sentence of life imprisonment for killing his wife. The Honorable Supreme Court recently held that setting a person on fire is an act of extreme cruelty and would fall under Section 302 of the IPC. I mean to say, he will be punished for murder. Dismissing his appeal, the bench of Honorable Justice Bella M. Trivedi and Uzal Bhuvan ordered that the appellant, whose sentence was suspended by the court in 2012, considering that he had undergone about 12 years of incarnation, surrender before jail authorities within 4 weeks. On his failing to do so, the jail authority shall bring it to the notice of the trial court, whereupon non-bail warrants be issued against him. The Honorable Court observed. Briefly putting about the case, the FIR against the appellant was first registered under Section 307 IPC when his wife was admitted in a hospital with burn injuries and gave a statement against him. As she later succumbed to his injuries, Section 302 was added. In her dying declaration, the appellant's wife had stated that he was an alcoholic who used to beat her when she would not give him money for buying liquor. On the day of incident, he had come home in a drunken state and raised similar demand. When she refused and told him to go sleep, the appellant poured kerosene on her and set her on fire. Later, he tried to pour butter over her to douse the fire. The appellant was convicted by the trial court under Section 302 IPC and sentenced to undergo life imprisonment. The decision of the trial court was upheld by the High Court. In 2012, the appellant moved the Supreme Court. The appeal was admitted, and taking note of the period of incarnation, he was released on bail. The appellant case before the Supreme Court was that he did not have any intention to kill his wife. Senior advocate Srajuddin appeared for the appellant and, relying on the dying declaration of the deceased wife, submitted that after pouring kerosene on his wife, the appellant had tried to extinguish the fire by pouring a bucket of water over her. Thus, it was contended the case fell under Part 1 of the Section 304 IPC and not under Section 302. This was the main defense by the appellant counsel. On the previous date of hearing, expressing dismay over non-appointment of any counsel in the matter to represent the state, the court had appointed M.S. Cure Aditya Singh. During the course of arguments, Singh asserted that the appellant's guilt had been proved beyond reasonable doubt and concurrent finding of the facts returned by two courts which need not be interfered with. After hearing the submissions and perusing the material, the bench observed that the plea sought to be raised before it on behalf of the appellant was neither raised as a defense during trial nor at the time of recording of his statement under Section 313 CRPC. Finding no infirmity in the impugned judgment, the appeal was dismissed. Counsels for the appellant was Senior Advocate Srajuddin, Advocate on record was Raghavan, Advocate Dibya Singhvi, Arya Kumari, and Stindra K.R. Visishta. And counsel for the respondents, Advocate Aditya Singh M.S. Curie. And for more details, you can go through the case title Naresh versus State of NCT of Delhi Criminal Appeal Number 1189 of 2012. And citation is 2024 Live Law SC 37. So, in this judgment, the importance of recording of statement under section 313 of CRPC has also been explained. So, this is all about the case. You can go into the judgment for more details. That's all. God bless you all.